I'm attorney Zach Townsend with Pro Legal Care. I have been handling high conflict family cases since 2011. The system would have you believe that it takes two people to have a high conflict family case. The truth is that usually there is one abuser and one victim. There are solutions for this type of problem, and I can help. High conflict relationships often deal with a lot of emotion, sometimes feelings over facts, denying reality, sometimes causing you to question your reality, causing you to be isolated or cut off from your resources, where it feels like not a partnership, but a competition. There's somebody who wants to win, or there are false narratives, there are fake emergencies, there is a lot of disingenuousness. Are you dealing with somebody who believes they're an expert at everything? Many people would say that these are symptoms of narcissistic behavior, but the important part is that the label doesn't matter. The label is not normally what the court would use. What the court would use are the actions, the behaviors, the conduct. You don't need a diagnosis. What you need is a documented pattern of behavior that is harmful or causes risk to you or your children. The courts generally don't look at what type of person you are or what type of person your opposing party is. The court looks at what have you done and what is the conduct that the parties have exhibited, events, facts, incidences, occurrences. That's what the court looks at, not what type of person are you. It's not uncommon for somebody who's in a relationship with someone of this nature to start to question themselves. Am I the problem? Am I the crazy one? That's part of the purpose of this type of behavior, is to cause you to question your own reality. Are you dealing with somebody who shows an attitude of entitlement? Someone that feels like they have ownership, the child is their possession, someone that talks about their child as if the child doesn't have any autonomy, uses words like access my child, puts their own needs ahead of the child's needs, someone who says the child's going to have to compromise and the child's going to have to deal with it because it's not the child's time, it's my time. That's the type of person that could make a high conflict family case drag on for years. We address those types of behaviors by not engaging on an emotional level. We don't play tug of war with those types of people. When you just have a couple of minutes before the judge, every little bit counts. And just the smallest distraction can take away from what's really important, can take away from what really happened, can take away from the truth. We can counter this by documenting everything. You need to have a journal, a log, a diary, a timeline, something where you jot down things that happen, notes, especially anything related to the children. Just take a few minutes each day, write down what happened. One of the ways to protect yourself best in a situation like this is to be organized and to be prepared. When you have a high conflict case with a narcissist, it is important that you deal with specific examples, not conclusions, not opinions, but specific events. What actually happened? That's why documenting everything is very important, because in court, we show, we don't tell. That means that we specify the facts that leads the judge to believe that this person has a problem. If you say this person has a problem, that's not going to be very persuasive. If you show that this person has a problem, that's going to be persuasive. Documenting incidences is simple. You write it down, but it's deceptively simple because it's powerful and it's very real. It brings to life what happened. The reason you want to document everything is because it doesn't help to just say, well, this happens all the time, because it's not specific. The point of documenting something is to be very specific. You want to make sure that you write down every time that there's a drop-off, every time that there's a pickup, really any time that there's communication. An easy way to do that is through a court-ordered app for parenting communication, where you have your messages that cannot be deleted. They're time-stamped for when they were sent and when they were last opened. They cannot be modified. They can be accessible directly from the provider of that communication tool. Having the facts detailed out helps you stay organized and helps you unmask the narcissist. It helps show the judge the true colors, who that person really is, because that's what this is about. They don't want the judge to know who they really are. That's why the details are so important. These methods are helpful when you're dealing with a high conflict family case. We don't need a diagnosis. A diagnosis is not specific facts and incidences and occurrences. That allows the judge to make their own conclusion. Parental alienation syndrome is something that a lot of people are bringing up in their high conflict family cases. It's not a medical syndrome. It's not in the DSM-5. It's not recognized by the World Health Organization. It's been denounced by countless institutions that are very credible among the medical field. Parental alienation syndrome is most often alleged against women to make them appear irrational or mentally unstable. Parental alienation syndrome is usually levied by men who have been accused of abuse. Often it's a way to turn around the accusation of abuse against the man. Claims of parental alienation can be dangerous because it often leads agencies such as child protection agencies or DCFS to not take reports of real abuse seriously. The symptoms of parental alienation are often synonymous with the effect of endangering or abusing a child. When two sides come to court and one side alleges that there's child abuse and the other side alleges that there's parental alienation, that clouds the case and that causes the case to potentially blame both sides. This is the time when it's most important to show, don't tell. When there's intentional confusion that's caused, a judge with a lot of cases in a limited amount of time maybe throws up their hands and says, looks like they're both part of the problem. That's when your documentation is very important, because instead of dealing with diagnoses, the court wants to hear about what actually happened, what led to where we are now. What people describe or allege as parental alienation can be broken down into various different actions or behaviors. And those actions or behaviors can be addressed with a court order and allows us to focus on tangible remedies that the court has the authority to grant that can help solve this problem. Withholding your children from you is often a way that a party will inflict pain on you, to put it bluntly. There are remedies for that. There are contempt of court remedies. The turnover of the child can be ordered as a police-enforced order. There can be attorney's fees that are required to be paid. There can be stiffer consequences for if it were to happen again. Parenting time can be modified, reduced, or eliminated for somebody who weaponizes parenting time. Involving the child in the disputes of the parties, speaking negatively about the other parent in front of the child, using the child as a messenger. These are also common tactics, and those can be resolved through a court order that prohibits that type of behavior, or if this happens at exchanges, perhaps requires the parties to remain in their respective vehicles. The use of co-parenting apps or communication tools can also help remove the child from the disputes of the parties. Behavior that puts the child in the middle endangers the child, jeopardizes the well-being of the child, and that can be a basis to require that one of the parents have supervised parenting time only. If you have an opposing party who is trying to intimidate the therapist or trying to not allow the child to get the help they need, there are remedies for that. Getting to the truth in cases where parental alienation is alleged is imperative. Having experts that help get to the truth is one of the ways that we overcome that. Custody evaluators, guardian ad litem, parenting coordinators, counselors and therapists, parenting capacity evaluators, all kinds of experts that will help get to the truth and help uncover what's really going on here. Post-separation abuse is often an issue in high-conflict family cases. If you dealt with somebody who was controlling while you were in the relationship, chances are they're going to want to remain controlling after the relationship ends, sometimes even more so. Post-separation abuse is rooted in the control that somebody thinks that they're entitled to. It's about ownership and what you owe to that person. It's about ownership of your child. Post-separation abuse often comes from the concept that child is the only way that your ex has left to get through to you. When your ex wants to know where you are, your ex might say, I want to know where the child is. If your ex wants to know where you live, what your schedule is, they might say, I want to know the child's schedule. You owe me information about the child. All of these are symptoms of post-separation abuse. If you are being recorded, if your phone calls are being recorded by your ex, if your ex is taking video recordings of you or audio recordings of you while you are at exchanges, this could constitute post-separation abuse. Does your ex contact people they have no business contacting? Your family, perhaps your employer, or a doctor? That can be a sign of post-separation abuse. Many of these are early warning signs that you may need an order of protection. I can help you through this, and I can help you protect you and your children. Litigation abuse is a tactic that's common among high conflict family cases. If your opposing party wants to keep you stuck, that can happen. Litigation is very difficult, very stressful, and your ex probably knows that it causes you stress and causes you to maybe even lose sleep or affect your appetite. And some people know that they can keep your claws in you by keeping you engaged in litigation. That's litigation abuse. We have tools for that. We can have restrictions on the content of pleadings. We can have page limits. We can have what's called a pre-filing injunction, which means that the person who has caused you abuse through litigation may be required to file a motion requesting permission to file the request that they would like to make. So it adds an extra step. It's another tool that we have to help people who have been bullied through litigation. The cost of litigation abuse can be astonishing. Tens of thousands of dollars dealing with false accusations. So much time, so much stress, and so much money, all based on a distraction put forth by your ex to keep you stuck. We can pursue attorney's fees for somebody who is filing frivolous and false motions just to keep you stuck in court. When you're dealing with a vexatious litigant, we can pursue attorney's fees so that they have to pay what this has cost you. We can make this less interesting for your ex, less rewarding for your ex, more costly for your ex, so that way they can leave you alone and you can get out of court. You need help. You need someone who's dealt with this type of a person before. You need someone who recognizes these patterns of behavior, and I can help. Call me, we'll schedule a consultation and show you your new path forward.